Welcome to today's program. FTC proposes rule banning non-competes. Now what? Copies of the slides, a link to the recording, and the CLE verification form will be emailed to you in the days following the webinar. During the program, a CLE code will be read aloud, and you'll be required to include this code on the CLE form. Throughout the webinar, please feel free to type your questions into the chat box on your screen. Now, I'd like to turn it over to Dan Hart.
Thank you, Colleen. On January 5th, the Federal Trade Commission issued a notice that it plans to issue rules that would ban virtually all non-compete agreements with workers. This notice has kicked off a period of public comment on the proposed rules before they go into effect. It's also spurred a flurry of commentary in the business and legal press, and it sparked controversy that might be unprecedented in the 109-year history of the Federal Trade Commission. I'm Dan Hart. I'm a partner in Seyfarth's Atlanta office, and I'm joined today by a distinguished panel of experts to talk about this very hot topic. We have today with us Kate Pirelli, a partner in our Boston office, and the co-chair of our Trade Secrets Computer Fraud and Non-Competes Practice Group. We also have Mike Wexler, a Chicago partner, who is also co-chair of our Trade Secrets Practice Group. Robert Milligan, a Los Angeles-based partner, also co-chair of the practice group. And finally, Dawn Mertenite, a partner in our Boston office, who is the editor of our Trade Secrets Practice Group blog, which can be found at www.tradesecretslaw.com. We have quite a few topics to talk about today related to this very big topic. And to give you a sense of where we plan to go in this webinar, over the next hour or so, our panelists are going to first give you an overview of what the FTC's proposed rule says and does, and then also an overview of how we got here and what the FTC's reasoning or justification is for this sweeping proposed rule. We're next going to talk about some responses that have been generated in the business and legal community to this proposed rule, and some alternative approaches as an alternative to the approach that the FTC appears to be taking, at least in their initial draft rule. And then finally, we're going to talk about what to expect next, and especially practical tips that employers should consider right now, even during this comment and notice period. We're going to have plenty of opportunity, hopefully at the end, to answer some questions. So if you have any questions, please don't hesitate to send them throughout the presentation. So with that, let's get into it. And starting with Dawn Mertenite. Dawn, can you tell us what the proposed rule would do?
Thank you, Dan. As you mentioned at the top of this presentation, the proposed rule would effectively ban almost all non-competes. Now you see the text here of the proposed rule. This is the main clause. I'm going to try to shy away from just repeating a lot of the text that we see. However, I do think this is important to note. You can see here that the FTC's rule, the proposed rule, would create an unfair method of competition for an employer to enter into, attempt to enter into, or maintain a non-compete with a worker. Now, one thing I wanted to mention up front, the definition of worker in the proposed rule is very, very broad. It includes, obviously, employees. It also includes independent contractors, sole proprietors, basically everything but a franchisee. Franchisee is the only thing that is carved out from the definition of a worker per the proposed rule.
And Dawn, I see from the slide that the FTC uses the term non-compete clause. How do they define what's encompassed in non-compete clause?
So a non-compete clause as defined by this proposed rule, the definition is very, very broad. I know I just said that about the definition of a worker. I think you're going to hear that a lot from our panel throughout the hour. But the definition, as you can see here, it's a contract term between an employer and a worker that would prevent the worker from seeking additional new employment with a person or operating a business once that worker's employment with their current employer has terminated. Now, that's not all. You can see there's also this second clause here that is really surprising. It creates a so-called functional test to determine whether a contract clause is a de facto non-compete. And what the FTC means by that is a clause that might not be called a non-compete, might not be what most of us think of as a classic non-compete, but nonetheless essentially has the effect of prohibiting the worker from accepting a new job. And the interesting thing here is the FTC provided a few examples of what might be a de facto non-compete. And the very first example is a non-disclosure agreement that is so broad that it effectively prevents someone from joining a new company. And that, I think, was really surprising to all of us because I think most of us consider non-disclosure agreements relatively standard in employment agreements and not terribly controversial for the most part. So to see that be the first example of something that the FTC said, look, even this NDA, that might be a non-compete that is prohibited by this proposed rule, that's really surprising.
Yeah.
I should note that in the examples, non-solicits, whether employee non-solicits or customer non-solicits, are not identified. However, given that non-disclosure agreements have specifically been called out by the FTC, I think it's fair to assume that the FTC would consider a customer or employee non-solicit to potentially be a de facto non-compete.
So this is clearly very sweeping, particularly the inclusion of defining a non-disclosure agreement as a non-compete clause is very surprising. Are there any exceptions laid out in the rule, like for, RSU agreements or anything like that?
So there are very, very few exceptions. There's really only two exceptions. One, I just mentioned, the definition of a worker excludes a franchisee. But the main exception you can see here, the FTC has said that this rule will not apply to non-competes that are entered into in the context of the sale of a business. But there's a big caveat there because as you can see here, it says right around the middle here, a person who is selling all or substantially all of a business entity's operating assets when the person who is restricted by the non-compete is a substantial owner of, a substantial member, or substantial partner in the business entity. So that raises the question, all right, what is a substantial owner, member, or partner? And in the FTC's definitions under this proposed rule, that would be someone who has at least 25% interest in the business that's being sold. And that is really important to consider because there are lots of very important members of a business who might sell the business who don't have 25%. So you can imagine someone who might have been a founder of the company might still be the face of the company and in fact is the CEO of the company, but because of outside investments, that person only has 24% interest in the business. And what this proposed rule would do is say that 24% is not enough. So that person who's selling their 24% interest, even though they are the founder, even though they are the face of the company, they can't be bound by a non-compete.
So Dawn, I imagine a lot of employers are thinking, we've had non-competes for years. That's a big part of our business. Is this going to be just a prospective rule change? Or is this going to apply to agreements that were entered maybe 10 years ago?
So if this proposed rule only applied prospectively, it would still be a massive sea change. But as you can see here, the FTC has proposed that this proposed rule would apply even to already existing non-competes that are currently valid under relevant state law. So you can see here that this proposed rule would require employers to rescind their existing non-competes within a certain amount of time after the final rule, if a final rule is implemented.
So that raises another question. In 47 states, some form of non-competes after employment are allowed. And I can see a lot of employers saying, well, hold on now, I live in a state that allows non-competes. For example, here in Georgia, the legislature passed a law back in 2011 that specifically says it's the public policy of the state of Georgia to encourage reasonable non-compete and other restricted covenants. How is this FTC proposed rule going to interplay with existing state law?
So this proposed rule would completely exempt state law. And Dan, as you noted, we have many different states that have different rules. In addition to Georgia, Texas and Florida tend to be fairly favorable to non-competes, but this rule would supersede all of those state laws. The only caveat there is the FTC said, well, if it's a state in which the governing rules or laws are more pro-employee than this proposed rule, then the proposed rule would not preempt those laws. Now, it's hard to imagine that many state laws, even in the states that we think of as more pro-employee, would be even more favorable than this proposed rule, but that is one little carve out. And just to follow up on my last point as well, in addition to having to rescind the existing non-competes, the proposed rule would require employers to provide a personalized notice to the employees or other workers saying that the agreement is no longer in effect, it's been rescinded, it can't be enforced. And that obviously has very big implications for cases that are already in litigation. If an employer is pursuing violation of a former employee's non-compete, and all of a sudden the employer has to rescind the non-compete, that's going to be a big deal. It impacts business deals where, again, this scenario that I just mentioned, someone who was a founder and the face of the company agreed not to compete in exchange for millions and millions of dollars. When they sold the company, their interest in the company, and the FTC says, well, you only have 24%. So, the buyer has to rescind that non-compete. So it really has quite a broad impact.
Yeah, I'll say. Well, thank you for that, Dawn. And let's switch over to a related topic, and that's just how we got here. And I think for a lot of employers, the idea that the FTC is getting involved in this area comes as a huge surprise. But Robert Milligan, can you tell us what the FTC bases its rulemaking authority on with respect to this issue?
Absolutely, Dan. The FTC bases its rulemaking authority here on Section 5 of the Federal Trade Commission Act. And as you can see, the language in the Charging Act is quite broad. They're empowered, to prevent using unfair methods of competition in or affecting commerce, and unfair or deceptive acts or practice in or affecting commerce. So the charge is quite broad, but it's worth noting that Congress enacted the FTC Act in 1914, and in the intervening 109 years, the FTC has never previously attempted to regulate employee non-compete agreements as part of its rulemaking powers until now.
So that's very interesting. And Colleen, for the audience, if you can put on the next slide, that actually has, sorry, the slide before that has the text of the of section. Sorry, next after that. I'm sorry, keep going forward. Okay, actually stop there. So Robert, you mentioned that Congress enacted the FTC Act in 2014. Sorry, to go back a little bit, Colleen. There we go. Can you give an overview of how we went from a statute passed in 1914 to now in 2023, the FTC using authority under that statute to purport to issue rules on non-competes?
Absolutely, and in the document supporting the proposed rulemaking, it's a 210-page document, but the FTC tracks somewhat of their history of how we got to where we are now. And what we've seen is, over the past several years, employee non-competes have become a significant focus of organized labor after there was allegations that some employers were abusing non-compete agreements by deploying such agreements in ways that went beyond preventing unfair competition or protecting trade secrets. Cases such as hourly workers in retail industries. And so I think that really got the attention, and at least according to the FTC and its document in the mid-2010s, they began looking into employee non-competes. There were some committees during the Trump administration of 2016 through 2020, but it really came to a head in the run-up to the presidential election when then candidate Biden, pledged to eliminate non-compete clauses and no poaching agreements that hindered the ability of employees to seek higher wages, benefits, and working conditions by changing employers. And in fact, in the Biden-Harris, campaign website, it was an issue that they addressed, and they indicated that they believed that 40% of American workers have been subject to non-compete clauses, and if the workers had the freedom to move to another job, that they would expect to earn 5 to 10% more. And so during the Biden campaign, he pledged that he would work with Congress to eliminate all non-compete agreements, except the very few that are absolutely necessary to protect a narrowly defined category of trade secrets. And he also pledged to ban all no poaching agreements. So, this may come at us as a surprise to some, but certainly it was something that President Biden campaigned on. I don't know that the scope and breadth that Don discussed was ever envisioned, even in the campaign. So it's not a surprise that after taking office, President Biden then issued an executive order in July of 2021 entitled Promoting Competition in the American Economy. Now, that executive order did not impose any new rules or impact employee restrictive covenants in any way, but it did encourage the FTC to consider exercising its statutory rulemaking authority to curtail the unfair use of non-compete clauses and other clauses or agreements that may unfairly limit worker mobility. Now, I think at that time when that particular executive order came out, there was focus on the unfair use. And so I think there's confusion about whether that particular language was a precursor to the sort of the wholesale ban that we're looking at now. I think some in the legal community believed that it was foretelling some limited restrictions and limited curtailing, but not certainly the wholesale ban that we're seeing now. And that same day that President Biden issued the executive order in July of 2021, the FTC withdrew a position statement that it had placed guardrails, that had placed guardrails on the FTC's approach to regulating unfair methods of competition. There was a particular 2015 statement entitled The Withdrawal. And so this really signaled that the FTC would be making a much more aggressive interpretation to its enforcement powers under Section 5 of the FTC Act. And then we work in sort of lockstep to how we've gotten to here when they announced the proposed rule, I believe, on January 5th. And on November 10th of 2022, the majority on the FTC issued a new policy statement that outlined an expansive definition of unfair methods of competition and indicated that it would engage in an aggressive enforcement of actions that it regards as unfair methods of competition, even if those actions don't constitute violations of federal antitrust law. So that foretold that the FTC was going to be aggressively looking at its powers under Section 5. And this particular proposed rule, the day before this proposed rule came out, there was announcements that there had been enforcement actions brought against three companies, and that they had entered into consent orders related to their use of non-compete agreements with employees. And so it was sort of it was an acknowledgement and an example that the FTC was going to use Section 5 to enforce against companies using non-competes, and that was followed the very next day with this proposed rule.
And Robert, as far as we know, was that enforcement action that they announced the day before the rule, was that the first time the FTC has used Section 5 to go after employee non-competes?
I think that's the case. I think that in the 210 page reasoning for the proposed rule, they try to set a tone that federal government oversight and federal sort of case law with related to non-competes and how non-competes could potentially be violations of antitrust laws, that there's some history there. But I think it is fair to say that they have never exercised their rulemaking authority to go after employee non-competes.
So very helpful history of how we got here. Mike Wexler, can you dig in a little bit more into what the justification is that the FTC provides for this, and what your view is on those rationales and arguments that they're providing?
Sure, Dan. The justifications as a general matter that the FTC tries to use are just fraught with all kinds of problems. It is circular reasoning. It is incomplete reasoning. There are studies that are cited to that don't even go as far as the FTC claims. And then in a number of cases, if you read, there's a volume of materials. You can see the research, you can see you can go to the results of the studies, and the studies in a number of cases are inconclusive and have conclusions that go both ways, and yet the FTC is using it in one particular direction. The FTC even looks at certain case law, and I'll just say he's very generous with what judges have ruled in some of those cases, and have cherry-picked facts from some of the cases, ignoring the outcome of the case in certain situations where the outcome is not supportive at all of what the FTC is saying. So the FTC says, for example, and I'm not going to read off of the points in front of you, but the FTC claims that non-compete clauses bind about 1 in 5 Americans, about 50 million people, and that by preventing workers, that these prevent workers from moving across to different careers, and prevent workers from getting better working conditions. They claim it prevents people from hiring qualified workers. But when they make these broad sweeping statements, they're not analyzing these things by, for example, are we talking about executives? Are we talking about lower level workers? Are we talking about line workers? Are we talking about people who are in research and development? Are we talking about people who are who have the keys to the kingdom, or CEOs of a particular company, or in charge of business development? So they're casting these broad rationales, and they're not targeting these situations that where, for example, many businesses, they may have a line worker who doesn't even have a non-compete, and they may have a CEO that has a non-compete, or they have people in charge of research and development who are non-competes. And businesses, when you look at these justifications, they'll say, well, why would I want to develop? Why would I want to innovate if I can't protect those things, and someone can just leave and go to a competitor and go and work on the same widget that they're working on at their current employer? They claim that wages for workers are being reduced because of non-competes. And when you look at the studies that they try to justify that with, again, they don't look at it by industry. They don't look at about the actual factual scenarios involved here. And you can walk away with a conclusion that maybe there's situations where workers' wages may be reduced, and maybe they're talking about people who are working on a line or working at a lower level position at a company. But when you start then getting into the different roles of a company and you start assessing those things, the FTC really doesn't handle that. They try to claim that stifles new business. They try to claim that workers are exploited, and that non-competes hinder economic liberty. Well, I'd argue to you, and we've talked to a lot of our clients already about these issues, that where you take a worker who's part of a team that develops, let's say, a new product, and that worker leaves and goes to a competitor, and then that worker starts using information they're not supposed to use at the competitor, or they're placed in a very similar role, and they say, oh, I have a non-disclosure agreement, I'm not going to use anything. But people may consciously or subconsciously use that information. So now you have this team back at the prior employer that benefits from the sale of this nifty product, from the innovation that they've all made, I'd submit to you that all those workers are harmed by the one person that left and goes to the competitor and starts working on the same product at a competitor. The FTC also claims that the employers have other ways to protect trade secrets and other valuable investments that they've made. And they cite to trade secret statutes in different states. Well, that ignores the fact that in order to prove a trade secrets case, you actually have to show that you've taken reasonable measures to protect trade secrets. Part of the reasonable measures that virtually all the state's case law talks about is non-disclosure agreements, non-compete agreements. And here the FTC wants to ban non-compete agreements, which means it makes it harder to prove a trade secrets case. And they take issue with non-disclosure agreements even. So what are these ways that employers are supposed to protect things? Because the FTC doesn't even understand what the case law says and what has to be proven to protect trade secrets. Having a statute with no teeth, or having a judge saying, well, you don't have a non-compete or you don't have a non-disclosure agreement, you're not taking proper steps to protect your trade secrets. It's truly a nightmare for folks who need to protect their innovations and their intellectual capital. The FTC also has built an expertise on, they claim they have an expertise in non-competes through the years because of some workshops that they held in 2020 and 2021. Well, that's self-serving. That's like any of us saying we're the greatest attorney in the world. Just ask me. And so, I think this is highly orchestrated. Robert spoke earlier that they came out with 3 enforcement actions right before a day later they go and release this NPM with these new rules. There's a lot of, I think people could argue, political motivation here, and there's a lot of orchestration in how this all came out. In the rule, it invites in the NPM, it invites comments, and they estimate that workers' salaries would be increased by $300 billion per year and save consumers $148 billion per year. And yet the justification and backup for that is puzzling. When you look at the dissent by Commissioner Wilson takes to task much of these things that we've just gone over, that there are great holes in all this. There are legal challenges to this, as Dawn was talking about earlier. There are a lot of problems there. And we would encourage anyone to file a comment if they oppose this. And also, as a law firm, we're going to prepare a comment, and we would invite anyone on this call for your businesses. If you want to join in our comment, we'd be happy to work with you and join in the comment that we're going to file, pointing out some of the problems with this rule. And you can message us, you can email us, and let us know you'd like to participate and in that if you want to. And we'll also send something out after this seminar, in which you can you'll have information that you can then respond to and let us know if you're interested in participating in our comments.
Well, thanks for that overview, Mike. So we've got a sweeping proposed rule that the FTC's intending to enact after 109 years in its history of not ever acting in this area. We've got justifications that clearly are hotly contested, to say the least. Mike's already touched on this somewhat, but Kate Pirelli, can you give an overview of what the response has been so far to this proposed rule?
Sure, be happy to. Just to pick up where Mike left off, I think you could hear the passion and concern in Mike's voice, and we've been hearing that from the business community. And in fact, the U.S. Chamber of Commerce came out with a very strong statement, which appears before you on the screen, against this action. And we've been hearing from clients, every minute about the backlash of this proposed rule. But as the Chamber of Commerce points out, in its view and in many people's view and the dissent's view, as Mike mentioned, I'll talk about that in a moment in a little more detail, this proposed outright ban on non-compete clauses and all employer contracts is, according to the opinion of the U.S. Chamber of Commerce, blatantly unlawful. They're ignoring 800 years of common law on this, and Congress hasn't, 100 years rather, Congress has never delegated to the FTC anything close to the authority that it would need to promulgate such a rule along these lines. And the Chamber has pointed out that they're confident that the action won't stand. And I think a number of people share that view. And if we have time, we'll get into a little bit of the challenges that might be made against this legal challenges. You know, this came up moments after the notice of the rulemaking. It included this statement. It also went on to say that the statement that attempting to ban non-compete clauses in employment circumstances overturns well-established state laws, as we pointed out in the previous comments, that have governed in very fact-specific inquiries of whether employers and businesses' legitimate business interests need to be protected in the particular situation that is presented before the court that is reviewing the non-competes. And what the FTC is proposing is abandoning that approach and trying to endeavor into that fact-finding with what appears to be very little experience to do it. So therein lies the deep concern from the business community and many of the clients we're hearing from. And I'm sure if you Google reaction to this proposal, you'll see lots of criticism of this. If you can go to the next slide, the dissent that Mike mentioned and from Christine Wilson is about 14 pages, much shorter than the statement issued by the majority of the commission, but fairly scathing, and points out in vivid detail some of the problems with it. As you can see here, I'm not going to read this to you. She thinks that undertaking a radical departure from what appears to be a lack of clear evidence in the record before it, as it stands, to take this unprecedented outright ban. She goes on to say, and Mike mentioned this in some of the studies that the majority rely on. Most of those studies many were inconclusive, didn't reach conclusive results. Many of them were academic exercises to some degree, which were not across industries, were in various, not testing various industries, and they contain mixed results. And she goes on to say, in the opinion, and one of the quotes is lacking enforcement experience, the commission turns to academic literature and studies, but the current record before it shows that those studies are scant, contain mixed results, and provide insufficient support for the scope of the proposed rule. She also cites to a financial services industry study, which concluded that the negative unintended consequences of suspending non-compete provisions resulted in higher fees and broker misconduct. So actual harm to the public and from this type of approach. And she goes on to say that the suspension of non-competes across all industry sectors in the U.S. will undoubtedly impose a much larger raft of unintended consequences, similar to the financial study that I just mentioned, the financial industry. An interesting quote, and I think she includes herself in this, is that she says, with all due respect to the majority, I'm dubious that 3 unelected technocrats have somehow hit upon the right way to think about non-competes, and that all the preceding legal minds to examine this issue have gotten it wrong. And she said the current rulemaking record, and she's citing all the things that the majority cites to, or the majority statement cites to, in her view, doesn't convince her otherwise. And she goes on to talk about, you can go to the next slide, please. She goes on to talk about the lack of authority to do this. And as I said, if we have time, we'll get to that. But whether the FTC Act provides authority for this type of competition rulemaking, whether the Commission's authority would likely be questioned on the major questions doctrine, like it recently, the Supreme Court invalidated OSHA's vaccine mandates on the same principle, same doctrine. So she said those types of challenges are likely to befall the Commission if this goes forward. The other thing that was very interesting to me about her statement was that she spent time pointing out in that the types of information that she thinks people commenting on this proposed rule ought to address, and that some of that relates to the studies that both Mike and I mentioned, and whether or not such studies actually exist, and are there counter studies. So she lists, I think there's 6 or 7 points that she encourages us all, anybody who's concerned with this, to address and submit to the commission as part of the comment period. She also points out, and I think it shouldn't be lost, that there are, we're going to talk about this in a minute, there are some alternative approaches that the commission addresses in its statement of the majority, where they consider that they might be less, or state that they might be less restrictive in certain aspects, whether it's executive employees, whether it's across different sectors, perhaps different wage categories, scope of duties. And what the dissent says, to be sure, is that people comment on those alternative approaches as well, because in her view, she doubts there will be additional comment periods on these alternative approaches. So the comments ought to be very inclusive as to all the scenarios that are laid out in the majority statement. So it's been, Dan, it's been swift and vigorous, and people are quite concerned, and the business community is quite concerned at the overbreadth of this proposed rule.
So, Kate, that brings us to what some alternatives would be. I'm curious from Kate or anybody on the panel, what are some of the alternative approaches that we could see the FTC potentially taking if they don't, go the full way they've proposed here? Or what are some alternative approaches that could be taken either by Congress, Department of Labor, other federal agencies instead of the FTC's rule?
I think one of the things.
Sorry.
That's all right, Mike. I'll just turn it back over to you in just a moment. I think one of the things it might do, and it signals that it might be open to do, and maybe likely where they end up, given all the objections, is a more pared down version of this rule, which would ban non-competes for workers below certain compensation thresholds, like many of the states have done, something along those lines, or along categories of workers, non-exempt employees, that type of thing. But I'll turn it back to you, Mike. Go ahead.
I was just going to say that if you use 11 states who have passed low-wage worker statutes, that would be probably a good stepping off point for the FTC to follow what 11 states have done. And, obviously, as Dawn discussed earlier, there's a lot of problems, federalism issues, can the FTC really do this? The major questions doctrine, as well as the delegation doctrine, that there's no authority to do this. But, it seems to me that there's 2 other approaches here. One is that, make sure that clients are having very specific non-compete agreements, and potentially agreements that don't limit people from going to a competitor, but limit them going to certain roles, working with certain customers, things like that. And then I think there's some language, and this is just my opinion, I think there's language in what Dawn had discussed earlier in how they define a non-compete clause and how they define the application, where you can there's a workaround potentially based upon how they defined it. But those are things that will be borne out over the next several months, and provide alternatives. But I think you're going to have business, as you've said, business is very concerned about this. The chamber's concerned about this. Other very large associations that we're working with are very concerned about this. And I think there's going to be a lot of rancor here, back and forth for many months, and then the courts are going to get involved and probably go back up to the Supreme Court, just as the OSHA case and the EPA West Virginia case that was mentioned earlier.
Yeah, Mike, just to piggyback on that, I was just about to say that I wouldn't be surprised if after all the uproar and the comment period, what we'll see over the next couple of months, I wouldn't be surprised if the FTC does pare it back, at least in some fashion. But notwithstanding that, I nonetheless think that it will still face some challenges, and that someone will likely challenge the FTC's authority to regulate in this area entirely.
I think Chairman Khan is sort of, in her comments, she's indicating, take a good look at whether there should be exceptions for executives and executive, personnel. So sort of piggybacking on what Kate was saying about considerations of alternative with low wage workers. I think it's interesting that, if you were asked, C-suite executives, do you support a non-compete ban? It kind of, may pit their individual interests against their corporate interests. Obviously, I think other alternatives are going to be, pointing to the state legislatures and letting the state legislatures decide what's appropriate for their workforce. In the past, there's been proposed federal, legislation, and it did get some bicameral, bipartisan support, but I don't think that it really has been fully vetted in the committees. And I think that's why this is so problematic, is that, that's the part of the legislature, to address, to debate the issues and work it up through committee. I don't think it's been worked up, fully vetted in committees, these various issues about where it should apply, to low wage workers, or there should be other, there should be exceptions. But I think ultimately, before you get into your comments, I think you have to make a decision about whether you think the FTC should be playing in this space, and then you make a decision with respect to that. And after that, then take on, the proposed rule, and, point out what you think about the proposed rule and what flaws you see in the proposed rule.
And this is not an area where, there's this huge problem and no one has been able to do anything about it. As many of us have mentioned, we have all seen over the last 10 to 15 years just an explosion of legislative activity in the states. There, not only the state laws that have been passed over the last 10 to 15 years, but in addition, lots of bills that have been proposed but haven't passed or have been debated and pared back. So certainly we have seen that in the state legislatures, it's possible to say, in this state, we think non-competes should not be enforceable against someone who makes under $30,000, for example. So that's certainly a possibility. And I think that's part of our concern with the FTC coming in and saying, well, no, we've got this handled. It's not like the state legislatures have been doing nothing. I mean, I feel like every state has been debating proposed laws for the last several years.
And one of the statements in the the 210-page position statement on the rule is they talk about that you may still be able to have non-disclosure agreements, you may still be able to have non-solicitation agreements, and at the same time, one of the reasons for this proposed rule is uniformity. But you're not going to have uniformity. You're still going to have all 50 states on their various views on non-solicitation agreements and what's enforceable under those particular state laws as far as non-solicitation agreements, and what's considered an overly broad agreement under those state laws. But then you have the big hammer, and the big hammer is that if your non-disclosure agreement and your non-solicitation agreement operates as a de facto non-compete, then you could be hammered by the FTC, and you're not going to know until that you start seeing some of the enforcement actions against you. So it's such a malleable standard, and I don't think it brings the level of uniformity that's told in the position statement.
So I'd like to move on to what the next steps are. Before we get there, I'd like to provide the CLE code, which is required on the CLE verification form that will be emailed to you in the days following the webinar. And that code is SS6823. That's SS as in Seyfarth Shaw, 6823, SS6823. Now moving on to the next topic. Curious what the next steps are. Dawn, can you give any estimate as to how long it will be or what the next steps are until a final rule is issued?
Sure. So the press release that the FTC issued last week includes a note that the comment period is open for 60 days, and the deadline for commenting, according to that press release, is currently March 10th. That period might get extended. I would not be surprised if it does get extended, because again, this is an area where a lot of people have a lot of things to say. And then after that, the FTC will consider whether to implement the rule or a pared back rule. And if they do, at that point, it will have a compliance date. We don't know exactly when the compliance date would be, but it is likely to be around 180 days after any such rule is implemented.
So we've talked about some of the alternative approaches, even that the FTC has talked about, which seems to suggest that even they contemplate that maybe this approach is not going to fly. It's always dangerous for lawyers to be prognosticators of what's going to happen in the future. But I'm curious for this panel, do we think that the rule that's ultimately passed by or enacted by the FTC is going to be substantially the same as what we've seen already? Or do we expect there's going to be revisions down the road?
I'll chime in. I think we're going to see revisions. I think you're going to have, you have folks possibly like the U.S. Chamber who already has active litigation against the FTC on related issues, I'll call it, issues of authority. You're going to have other groups and other businesses that will likely take legal action against the FTC. You may even have attorney generals of different states take action on this because they're trying to usurp a state's authority, which in 100 years, the FTC hasn't taken this route. You may have state attorney generals that take action against the FTC with regard to this overreaching that they'll claim. I suspect that whether there'll be a legal challenge that says the FTC can't do this if that's the decision that's made, or whether the FTC relents in some kind of settlement where they come up with something closer to the low-wage worker statutes that we have in 11 states. That's probably a more likely result because this is clearly the far end of what happens here, right? You eliminate an agreement that has existed for years, and something Dawn said earlier, which can't be ignored, this rescission period within the 180-day compliance period that businesses are supposed to rescind agreements. Litigation's pending over non-competes all over the place, and what happens in those cases? That's clearly has not been thought through. You have businesses that have paid bonuses to individuals at high-level posts based upon signing a non-compete. You have individuals who are being paid for evergreen, under evergreen provisions. You're being paid to sit out. What's supposed to happen there? They're supposed to give back money. You have training that's affected by this. Training issues where monies have been paid and non-competes are tied to that. What happens with all those things? The FTC shows nothing in the NPM that has considered the practical effects of what they're talking about here for these rescission issues. So I can't imagine. I mean, we're just guessing. I guess I'd pick stocks if I knew for sure. But I just can't imagine that this in its same form is how this will look a year from now.
Yeah, and I would just add to that, Mike, Dawn and I in Massachusetts watched the Massachusetts legislature start over a decade ago. It's got to be 2008-9. They started, certain legislatures trying to ban non-competes altogether. And it went on and on and on and on through various iterations for the next decade. And finally, in 2018, there was a statute enacted that didn't do that, but certainly put some restrictions and modifications on non-competes in terms of low-wage workers, in terms of the length of the restriction. And so I imagine this is, if it goes to a final conclusive path, it's going to follow a similar path. We've kind of seen this story on the state level, and I think it's happened in other states as well. You start large and you whittle back, and I think there's probably a strategy to that as well.
Well, those who are tuning in can hear probably from the background noise that we are having torrential storms here in Atlanta. So maybe it's appropriate that the sky seems to be falling, given all the risks to businesses that we've been talking about. We've touched on this. I suppose the big elephant in the room here is, regardless of how reasonable or unreasonable the FTC's final rule is, do they even have authority to promulgate rules in this area? For anyone on the panel, what are the most likely challenges to the existence of rulemaking at all?
I think it was touched on earlier, the EPA versus West Virginia case where the EPA promulgated rules that went far beyond their authority. The Supreme Court said under the major questions doctrine that the EPA doesn't have the authority to regulate the way they did and overstep the states essentially, or overstep Congress in particular. You have, I think Dawn mentioned it, the non-delegation doctrine, which talks about that Congress didn't delegate this authority to the FTC. That Section 5 has not been used in this way for, at any time before. I think, as the dissent said, 100 years, they never touched this area. There are a number of issues. I don't know, Dawn, Robert, Kate, do you want to chime in, or Dan even, do you want to chime in on other issues, constitutional, et cetera?
Yeah, I'll add to that, Mike, that, I think there's a serious question here about the major questions doctrine. The Supreme Court last term, as has already been alluded to, struck down federal agency regulations on the basis of that doctrine. And the term the Supreme Court likes to use is that Congress doesn't usually hide elephants in mouse holes on a matter of significant economic and political impact on the country. And one would expect that if Congress had intended to delegate to the FTC the power to issue rules about employee non-competes and to supersede state law in the process, that they would have been clear about doing it. There's a related doctrine that's had some more attention from at least some of the Supreme Court in past years, recent years, and that's the non-delegation doctrine. And so the argument there would be, even if Congress had intended to delegate to the FTC power to issue rules over this area, it can't do so on the basis of a vague statement like, unfair methods of competition. You have to have a little more direction to the agency in order to be able to enact rules. And you can see in some of the alternatives that the FTC has proposed, the kind of back and forth compromising that normally you would expect to see in the legislative process, not in the rulemaking process, on the theory that the elected representatives, unlike, as Kate talked about, the unelected technocrats, are more answerable to voters. And that's the branch of the government that really should be making the law, as opposed to the executive branch, which should be carrying it out.
Dan, what should employers be doing about this? Do you think, or anyone else on the panel, do you think they should be doing?
Before we get to that, I just want to give a quick plug, because Dan didn't do it, but Dan just co-authored a really great piece that we just posted on our blog, literally minutes before this panel started. He co-authored it with two of our partners that delves a little bit into what he was just talking about, that if you're interested in some of the constitutional challenges, I urge you to look at it, because I think it's fantastic. But to answer your question, Mike, I think you said earlier, it's business as usual. I think that's true. I think our advice to employers all along has been, try to craft an agreement that complies with the relevant state law. Right now, we don't know that this proposed rule is going to go into effect. We don't know that any proposed rule is going to go into effect, or if it does, whether the Supreme Court will permit it or not. So I think for the time being, employers should be looking at their agreements, as they always should, to make sure that it's supported by a legitimate business interest and otherwise complies with state law.
I would say that you should, the company should, weigh in. The company should take a position. So in-house counsel, HR professionals, then you should try to galvanize and see what the company's, sort of position is on this issue, and consult with your counsel or make your own sort of public comment on the issue. I think one thing to keep in mind is that, as we indicated, before the rule was announced, the proposed rule was announced, they kicked it off the day before by enforcing against, 3 companies that they viewed as having, non-competes that interfere with competition. And so, there's that sort of backdrop. It's sort of the carrot and stick approach. So if you're in one of those industries, and those particular industries were security personnel and glass manufacturing, but you can extrapolate, across the board as far as if you're using, non-competes with low-wage workers. At this point in time, you just want to wait and see how it plays out and gets tied up in the courts. Or do you want to make any sort of meaningful changes? Perhaps you were a company that was, you pushed the envelope a little bit on your non-competes. You may want to at least have that conversation and be circumspect about, do we want to pare down our program, or you want to kind of wait and see how this plays out in the courts? But be wary that, that the FTC is moving forward on enforcement actions, regardless of this, proposed rule. So that's one thing, to keep in mind.
I think it's important too, and my audio dropped for a minute. I hope this was said already, I apologize, but to look at your other agreements too, the non-disclosure agreements, as well as non-solicits. And I know non-solicits aren't addressed specifically, but under this approach that the commission is taking, you can see them going there. So you just want to make sure that the language of those agreements are drafted narrowly and, could not be viewed as a non-compete, a back end run non-compete. I'm not sure what that language would look like, but it's worth talking about with your counsel to make sure that that's not the case.
And I think at a minimum, you should be, complying with state law. And, Seyfarth has our sort of 50 state resource and keeps people up to date on the latest changes in the non-compete laws in the individual states. And so at a minimum, you need to make sure that your agreements are in, compliance with some of the recent changes, in state law, some having to do with lower wage workers, some having to do with notice. But at a minimum, you need to make sure that you're in compliance with state court law or state law. And I think that could be one of the alternatives too, if there's not enough traction and the FTC's movement gets bogged down in the courts, that don't be surprised to continue to see, state legislation in this area as well.
Well, we've received a lot of questions during the presentation, and shortly we'll move on to question and answer time, and we'll stay on for a little bit past the hour, knowing that there's quite a few things to talk about. Before I move on, any final thoughts from the panel about anything that employers should be thinking about at this point?
Not for me, Dan.
I have just a brief comment. I think this stresses the importance of trade secrets. And so if specific trade secrets are near and dear to your company, and you are really sort of just relying on the prophylactic measure of a non-compete, to protect those trade secrets, you may really need to shore up your non-disclosure and your non-solicit to make sure that you are able to enforce, because there may be additional scrutiny of your non-compete. But if you do have those effective, narrowly tailored non-disclosure agreements, you'll be okay if you need to enforce against an employee or a business partner that may misappropriate that information.
Well, that's a great point, Robert. Before we move on to the questions, I want to note that we will be continuing to track developments on this really hot topic. We've had a couple blog posts up already. I encourage everyone to check out our blog, www.tradesecretslaw.com, where we're going to continue to monitor developments as they come along. And Robert's already mentioned our 50-state desktop reference. That tracks the requirements of state law, which does govern non-competes at this point. And we'd encourage everyone to take a look at that and make sure that their agreements are compliant with this ever-evolving area of the law. Let's move on to some questions at this point. And one question came in just about the process of the rulemaking. And the question is, do we anticipate that there will be another period of comment and notice if the FTC decides to adopt a different rule than the originally proposed rule, or if this is basically it. This is the last time to be able to comment on the proposed rule before a final rule goes into effect. Any thoughts from the panel on that?
Yeah, Dan, I just would, I don't know that we've heard from the majority, but certainly Commissioner Wilson mentioned that she did not think there would be additional comment time, which is why she thought it was so important to comment on the suggested or possible alternatives or variations on the all-out ban theme. So it's, at least from her perspective, there won't be. I don't know if that's the final word, though.
And to follow up on Kate's point, as of yesterday, early in the day, there were approximately 400 comments that had already been submitted. Now, that could be anything from, the pizza delivery person that says, yeah, hey, do away with non-competes, to other more substantive comments. But we did not check today, admittedly, but with the number of comments and how this is so controversial, there might be additional time. You don't know, but you have to take Commissioner Wilson's, to Kate's point, Commissioner Wilson's admonishment that, this is the time to do it. Folks who are interested in commenting really should do so prior to March 10th to make sure they're heard.
Another question came in pointing out that the federal government itself sometimes has non-competes. Is there any reason to think that the federal government would be exempt from this rule, or would this apply across the board to public and private sector employees?
A great question.
Thoughts?
I don't know that it was addressed.
I read through the 216 pages of the NPM, and I don't. As Dawn pointed out earlier, it's so broad with what they're proposing, the definition of workers and businesses and non-competes, and it would be somewhat hypocritical if it only applied to private business and didn't apply to the government, don't you think? But I don't recall in that specific question being answered in the NPM. I think the question was raised in defense contracts by whoever wrote that question. I did not see something that was applicable to that situation that the person who wrote this question brought up.
I do think that's the intent. I think there's a small section. It may not be the clearest. I think that is the intent, that it would apply to the federal government. I think there's an issue with respect to whether they have the authority to bind a state government. But I think certainly the intent is to make it as broad and apply to the private and the public sector.
Another question that's come up is in the context of employment agencies or temporary staffing agencies. Is there any exception in this rule as proposed that would allow employment agencies to have a non-compete with their employees, their temps, to prevent those folks from going to work for a competitor agency or directly for the client employer, or is this going to apply to those kind of agreements as well? Any thoughts?
I think it applies.
And I'll expand on that slightly because of another question. I think you'll answer both. Is the descriptions of different situations in the NPM. It does sort of. I think it will apply to anyone in any contractual situation. However, there is an exception that's alluded to with regard to during employment, what someone can do while they're currently employed by one employer, what they could do with another employer. It doesn't seem to prohibit some kind of restriction on an employee while they're currently employed. These things tend to apply when someone terminates. So it would be a post-employment, but this also applies to independent contractors. So I'll just say a post relationship with a company position is what this refers to.
I think one thing that, this is going to build momentum as people sort of unpack what exactly is being proposed here. And right now, sort of the focus is on, HR, labor and employment interactions with workers. But I think what you're going to be beginning to see is a acknowledgement that, wow, this might impact my business deal. This might impact the transaction that I just did when I brought over, I did a $100 million transaction, and I brought over 20 key employees who are bound by non-competes. That could impact them. So this is going to impact business transactions. Now the proposed rule doesn't impact business to business non-competes, and so that's going to be a whole area of itself. It's like maybe they're not an employee, maybe they're not a contractor, maybe they're their own business, right? But more importantly, it has this artificial 25% threshold on the business transaction, and having a non-compete with an employee that's part of that business transaction that they sold their interest. And it's a very artificial number, because if you look at say it's a transaction of $100,000 transaction, well, by its terms, you could only have 4 people that would be bound by the non-compete, 25% interest. But what if the transaction is, hundreds of millions of dollars, and there's more people that are involved in the sale of that transaction that are staying on as key employees? So that's not only going to apply to those transactions the new transactions on a going forward basis, but also transactions from the past. So I think the business community is going to look at this and say, wait a second, whether or not we allow this with low wage workers, why are we applying this retroactively, and why are we allowing the federal government to interfere with our well-settled business transactions? I don't think there was any charge with respect to that.
And Robert,
I think the commission even recognizes that, Robert. I mean, that it's one of the areas that they invite comment on, like what a substantial ownership means, and maybe that's something less than 25%. And again, I think this is part of perhaps what the strategy is: start broad and maybe narrow it, but they even identify it as a very potent issue. Sorry, John, go ahead.
No, your last comment, Robert, about the business deals with more than 4 owners, that actually I did see a question in here. Someone said, well, what if you have a family business where it's 5 sisters or 5 family members, and they sell their family business? That means, and they own it equally, none of them can be bound by a non-compete. And as this rule is drafted, yeah, none of them would be bound, because they would each only have 20%, and that seems kind of crazy. One question I had for the rest of you that I hadn't thought of until now: do you think this is going to spur more litigation in the meantime? Because I know from my personal experience, after Massachusetts passed the 2018 statute, which added certain requirements for non-competes, we heard from so many people who said, well, non-competes are not enforceable in Massachusetts anymore. And we had to say, well, that's not true. They're still enforceable, but you need to meet certain thresholds that weren't in place beforehand. And I'm just curious if you think that there will be workers who say, oh, I hear that there's a ban on non-competes, so now I can go wherever I want. And right now it's not in effect. So I'm just curious if any of you foresee additional litigation as a result of this, and the fact that the public might not understand that it's not a final rule yet.
I do. I absolutely
so.
do, because I saw the same phenomenon before. I think even before this came out, there's a view in some quarters that non-competes are not enforceable.
Right.
In Massachusetts, so this will just be more fodder, I think, for that view, but it is not in effect yet.
And
right. Go ahead. Sorry, go ahead. I was going to say, I think the public's consciousness, what they get from the media reports is, okay, non-competes are gone, right? Well, that hasn't happened yet. And are they taking into account the appreciation, the difference between a non-solicit, which is even allowed under the FTC, and a non-disclosure that's even allowed under the FTC, and a non-compete? And you can very well predict the conversation as, oh, I thought non-competes were no good. Oh, but we're trying to enforce our non-solicit. That means that you can't be, taking our customer list. You can't be taking our customers and that you worked with. So I think there's going to be a tremendous amount of confusion. I do agree, Dawn, that there could be additional litigation because of the misunderstandings.
And then the argument from the FTC to what Dawn and Robert just says, their argument would be a non-solicit and non-disclosures, that they'll try to say, oh, those are de facto non-competes in some fashion. So that'll spur litigation over what that means. And then I'll just bring up something with Robert, who's based in California, is very familiar with, is people are always like, oh, non-competes are illegal in California. Well, yeah, under certain circumstances. For example, sale of a business, they're not improper. Agreements, non-competes that are drafted to protect trade secrets in a specific fashion are acceptable. So, the public will, or the worker may have a perception that's not jiving with what the law says in a number of these jurisdictions. To the point that Kate made earlier about Massachusetts, they didn't undo them. They just said, okay, they apply to certain folks and under certain conditions. You need to give notice and all those things. So yeah, I think there's gonna be a lot of misconceptions about whatever happens here, unless the Supreme Court strikes it down or a compromise is reached. I think there'll be misconceptions across the board.
Yeah, I mean, even in California, the magic number is not 25%. There's case law that has much less, somebody being considered a key person in a transaction where they have an employee, non-compete. So where they arrived at the 25% as being a fair measure of somebody having a substantial ownership interest, it seems quite arbitrary.
So in the interest of time, I think we need to wrap it up. Obviously, this is such a popular topic, generating so many questions. We could probably talk about this for another hour, given all the interest in this. If you submitted a question and we didn't get a chance to address it, please be on the lookout for an email from us. And I want to thank everybody who's attended today virtually, or people who will be attending in the future via the on-demand function. And I want to thank all of our panelists today. In the meantime, if anybody has a question, please don't hesitate to reach out to us. We've included our phone numbers and email addresses on the final slide. And again, please continue to look at our blog, www.tradesecretslaw.com, as we continue to track these very important developments. Thank you all.